Hey everybody, John Skiba here from the Arizona Consumer Law Group. I'm also founder of the Consumer Warrior Project. You can learn more about both of those over at consumerwarrior.com. In today's video, I want to talk about something that is a plague on society, a financial plague that a lot of people don't know about. Even a lot of attorneys that work in the debt collection world aren't aware of the scope of the problem that are default judgments. And I can tell you with my law practice, not a day goes by that I don't talk to someone who has a default judgment that's been entered against them, either by a credit card company, more likely by one of the debt collectors like a junk debt buyer like Midland Funding, Portfolio Recovery, Cavalry SPV, Cash LLC. That's another one that we see a lot of. A lot of people end up with default judgments against them, and they're not sure what to do about it, and they're not even sure how it is that it got to that point. So what I wanted to do in today's video is talk about how and why default judgments get entered against you and what you can do about it. As far as why the default judgment happens, the typical thing that I hear from people when they come into my office is, hey, my wages are getting garnished. I have this default judgment. I didn't even know this lawsuit existed, and now, I'm dealing with this big mess. And the reason why the default judgment is there, and most people aren't even aware of it, is because of the way that the junk debt buyer obtains the default judgment. And let me back up just a bit. How this happens is when someone is sued. So the lawsuit is filed by the debt collector. They're required to take that lawsuit and serve the person with it. They're required to literally come by and put it in their hands, a copy of the complaint and the summons, and then they have an opportunity to respond. Now, in Arizona, you get 20 days to respond to the lawsuit. And if you don't respond to the lawsuit within that 20 days, then the court assumes that you must agree with what they're doing or you're not going to contest it, and they enter a judgment against you for the full amount, usually with attorney's fees, court costs, and everything else. And you don't want to go that route because once a judgment is entered, that's when the collector has all the power. They can then garnish your wages. They can levy money out of your bank account and basically make life miserable. Now, the issue with most of these cases, when the default judgment is entered, it all goes back to service of the complaint and summons. Now, the summons and complaint, like I said, generally they have to be served personally, where a process server or a constable comes by and literally puts it in your hand. But what we see with most of these is that service doesn't go exactly like that. And because of that, over 90% of credit card collection lawsuits end in a default judgment. Here's what we see in my practice, what we see typically happens. The first one is that they will claim that they don't have an appropriate address. So they send a process server out, they come by multiple times, and they're not able to serve you. So what they then do is they go to the court and they ask for permission to serve you through an alternative method. Usually these alternative methods are not designed to give anybody actually any notice that the lawsuit is actually pending. It used to be they would allow people to post a complaint in the summons, like in the classified section of a newspaper. We don't see that as much anymore just because newspapers don't really exist in a lot of cities anymore. So what they're often doing is they're allowing them to send a certified copy of the complaint in the summons to somebody's house, as well as come and post a copy on the door, which seems funny because they've already established that they can't get you at that particular address. They haven't been able to come by and either get you home or the address is wrong, but then the court's now allowing them to mail it and post it on that address where you already know that you're not there. So that's that's one of the biggest things we see is alternative service, and then people aren't aware that they've actually been served. The 20 days goes by and the default judgment gets entered. Something that we also see is when another family member gets served. A lot of people are under the mistaken belief that they have to be the one personally to receive the summons and complaint. And if they drop it off with, say, like your teenage kid who's at home or with a spouse, something like that, that they can, that doesn't count. That's not true. If they leave it with someone at your home who lives there, they actually have to reside in the home, and as long as they look of suitable age and discretion is the word of the statute, then that counts. Then they've served you with a complaint in the summons, and that 20-day clock starts ticking. So those are the types of things that we see why people don't get notice of it. They do get notice through a family member, but they don't think that it's legitimate, so they don't respond to it. The more common scenario is where service is just bad completely. They serve it to the wrong address. They serve it to the wrong person. I've even had cases where the process server has flat out lied. It's not a majority of cases by any means, but I've had it where they said they've served them in a specific location, and we were able to prove that my client wasn't even there. They weren't even in the state at the time, yet they filed an affidavit with the court stating that they had served them appropriately. So what do? If you have this default judgment, particularly if you're facing wage garnishment, what are your different options as far as dealing with this? And what I want to do, I want to give you 3 options as far as what you can do to get rid of the default judgment. The first one is you can contest it. You can go in and you can tell the court that you weren't served appropriately, assuming that that's true, and that you want an opportunity to contest the allegations in the complaint and the summons that should have been served upon you directly. Now, in order for this to be successful, you're going to have to be able to show that by preponderance of the evidence that you were not served. This doesn't mean you can't just go into the court and say, hey, I wasn't served, Judge. I'd like a chance now to come in and defend this. You've got to show that there was something, like in that case I was talking about before, where we were able to show that my client wasn't even in the state. We were able to come in with documented proof showing that she wasn't in the state and that the process server had lied in the affidavit. And so what you need to do first to be able to decide whether this is even an option, go down to the court that issued the default judgment and ask to see a copy of the certificate of service or the affidavit of service. This is the document filed by the process server stating who it is that they served, when they served them. They even have a physical description of the person. You're going to need this. This document is key. Anytime I have someone come in with a default judgment, that's the first thing I tell them we got to see is, were they actually served? Because if I get the affidavit of service and it says that they served you and it has a physical description of someone who looks like you, it's going to be really tough unless we have some kind of proof that you weren't there at that time. We have a witness that you were at work or that you were at a wedding out of state or something like that. It's going to be very difficult to get that set aside. Likewise, if it says that they served a spouse or if they served, like I said, your teenage son or your daughter, those things count as service. We're not going to win that. But if they didn't follow through with the requirements of alternative service, if they didn't send it to you in the mail, if they didn't post it on your door, if they left it at the wrong address, those types of things, then yeah, we can go in and we can contest those and get that judgment set aside. In Arizona, the law is very clear that says if they didn't do the first step right, if they didn't do service correctly, then it doesn't matter how long it's been, the court must unwind that, and the court has no discretion in doing so. So that's one way to undo the default judgment. The second one is if you look at the affidavit of service and it looks like service was legitimate, or if you recall being served but you didn't know you had to respond or whatever, but you ended up with a default judgment, you can try to settle the claim at that point. I can tell you if they already have a wage garnishment in place, it's going to be pretty tough to do that because they don't have a whole lot of motivation to make that happen. But you can try to settle it where you're offering something to the creditor less than what it is that they're seeking, just to try to get the thing resolved and get it to go away. Third option is bankruptcy. Bankruptcy is kind of our nuclear option with all of this. It's always there in your back pocket. It eliminates judgments completely. It eliminates underlying debt. It stops wage garnishments. It's usually one of the last resorts that we look at. There's different things, like I said, whether it's contesting it, settling it. But if neither of those are an option, or if you have a lot of other debt issues, if the default judgment's just kind of tip of the iceberg thing, then it's something where we can go back, look at the bankruptcy option, and just deal with everything all at once. So the default judgments it's a stressful thing. It's a very frustrating thing just because it's such a huge problem, particularly here in the state of Arizona. We see just thousands of these things entered every single month because of bad service problems. I can tell you, I always think it's funny because they will, they always come in and say that, hey, we can't find them to serve them, but as soon as they get that judgment, they're able to find them real quick when it comes time to do wage garnishment. So that's my own bias coming through on this. But so that's really how you can deal with default judgments. Again, you're looking at filing a motion to vacate. You can settle it or you can file for bankruptcy. One little note, if you do file a motion to vacate, that does eliminate the judgment, but what it does not do, it doesn't eliminate the entire lawsuit. The plaintiffs can still come in, the debt collector can still come in and try to prove their case. It just gives you an opportunity to defend it. I can tell you in most cases, if that happens, it's probably just going to go away completely. But a lot of people think, well, we win the motion to vacate, then case is over, and that's not true. They can still come in and try to contest it. So that's going to do it for today's video. If you want to learn more about how to solve some of these big debt problems, you can head on over to consumerwarrior.com. I have about 500 articles that I've written over there, as well as a number of these videos, audio podcasts, with some different tips and strategies on how to deal with debt problems. Thanks for watching today.